Your Lordship, Lordship, I beg to mention item number 11, Your Lordship, on behalf of Mr. S.K. Talukdar. My Lord, it's a medical emergency, my Lord. Kindly the matter may be adjourned for the day.
On the prayer made on behalf of Mr. S.K. Talukdar, Learned Counsel for the petition. It is what I do know. Did you list this matter after?
Well, for adjourn for a day, Your Lordship.
For a week.
My Lord, similar prayer to item number 15 also, my Lord.
15. Okay, prayer, 11 and 15.
Obliged, Your Lordship.
Yes.
Lordship, in regard to item number 12, with consent of the other side, I pray for 2 weeks time, Your Lordship, to file my affidavit.
My Lord, I am for the respondent number 6, my Lord. By order, they mentioned, my Lord.
Let's come by order. You have not taken consent.
No, they have informed me, my Lord. We mentioned it, my Lord, for this.
When both of you are agreeable, what should I
My
come
Lord,
in?
next week, my Lord.
On the prayer made by the parties to the proceeding, list the matter
Lordship, and also my
10
senior,
days on a date to be fixed by the registry.
Lordship, and also my senior's name is not shown in the cause list.
Your name is shown. Your name is shown.
Not.
Your senior's name?
Mr. J. Abedin.
Eh?
Mr. J. Abedin.
J. Abedin.
Yes.
For the petitioner. Name of Mr. J. Abedin, Learned Counsel, be reflected in the cause list for the petitioner.
Obliged, Your Lordship.
May I please, Your Lordship?
Yes, Mr.
Lordship, I beg to mention a matter for listing. Lordship,
No,
review
not yet.
petition.
Not yet. This is not the bench.
Review petition, Lordship.
Review petition.
Lordship. Next
I don't
week.
know. I don't know. I don't know when I will sit.
Next week, Lordship.
16th.
16th, Lordship. Much obliged, Lordship.
Daily course list, admission item 1 to 3.
I have filed a reply also.
Oh, your file a report.
But it's only APSC has, APSC, that's hardly because I can, it's not maybe if I can give a copy to Your Lordship.
Oh, I did not see. When yesterday you filed?
Today.
Today. Oh, it has not. That's
I'll
why
give a copy.
I was in a doubt.
I'll give a copy.
Oh, that'll do, Mr.
I'll give a copy.
Mr. Monto seems to be a little bit apprehensive. Anything?
No, anyway, my lord, I have not seen the affidavit, but anyway, my lord,
Is only denying those particular.
He has
statements.
refuted your contentions.
Yes, refuting his contention. My lord, before Your Lordship.
So we are taking it up for final disposal.
Yes, Your Lordship, before opening of the file, I'll just point out the brief. So that Your Lordship will be easier to connect the entire. My lord, somewhere in, I'll give the dates also. 2017, there was.
Just give a broad,
Just
broad thing and
aerial,
then we will go deep.
just an aerial view. I'll give.
Aerial view, that is it.
My lord, there was an advertisement for some few appointments in respect of engineering college and polytechnic. Now we are into engineering college for filling up the post of assistant professor. Engineering college, technical, non-technical, Your Lordship is out. We are not concerned about non-technical, we are concerned about technical for filling up the post. So few posts was advertised. Now in pursuance of that, they have given the qualification. What will be the qualification? And how it will be conducted. They said that testimonial will be, they will scrutinize the testimonial of all the candidates and either on the basis of the scrutiny or testimonial, they will decide, or OMR, the written test will be held, which is no
This is the prescription in the advertisement.
advertised. I'll show it later. So, in pursuance to that, they went ahead. OMR written test was held. Now, this is interesting. When the written test was held, this petitioner also has qualified. This petitioner before Your Lordship was qualified in the written test. Now, the list, they notified a list, which candidates qualified. Now, these candidates which was qualified, for the first time they said, whichever the candidates have qualified, the local language test will be held. They have to sit for local language test.
This was not a prescription in the
Not in the prescription they advertised, but we did not object. We did not object to it.
So
We said.
The rules of
That's
the
the
game
point.
you have waived.
That's the point, my lord. We did not. Maybe it was not prescribed in the advertisement. We who on protest also was not done. We said, and ultimately it was advertised on which date the local language test will be held. Now, all these candidates are set for the local language test.
Hmm.
But when they knew the ultimate select list was notified after holding of the local language test, we have seen that all these petitioner name was not in the final select list.
Hmm.
We are aggrieved by that and we are before this honorable court. Now, while we have seen, checked all those particular candidates, which has final select list was issued by the authority concerned, we found that there were a lot of anomalies. How, my lord? I'll just few example. In that, the final select list, there was candidates, 345 your lordship will kindly just remember the date, the figure. 345 was selected in the final select list. 345
Against various departments.
against various departments. Now, 345 was then we have seen, checked, a particular candidate which we made a statement, a particular candidate who did not qualify also, he did not have the requisite qualification. Like, my lord, let us put an example that for a particular branch, you should have ME and a BE and ME. Now, that particular candidate, we have given the facts and figure. He, 2016, this is 2017, he completed these B, but ME he is not completed. ME he completed only in 2018. So we brought notice to the court, how you have done it, how selection. This initial particular, while you scrutinize, he should be out. Because for a particular post, B and ME was mandatory. So how you have done it? You could not have done it. Now, another example we have given, here we have noted down in my submission in pleadings, we have said for a particular branch, B and ME is required. Now, what has been done? One candidate, for an example, civil engineering, he has B, but ME he has got electronics in ME. So how can you select it? You can't select it. These are all
Pardon, I did not get it. B in
B, Bachelor of Engineering in ME.
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 No, B was in which subject?
B was in a different subject, civil engineering.
But
ME is something different subject.
And the post that was recruited?
Yes.
No, the post that
Post
was
which was civil engineering.
civil
In
engineering.
civil engineering, you need B and ME. So this was our contention before the learned single judge while moving this matter. Then the learned single judge, while initial I am talking about
I got it.
then initially it was moved.
Remanded.
Then the court said how you can do it, issue a notice and intimate that they will bring forward the record and notify the court how you have done this selection. 345 candidates. Now they came before the court, my learned friend said they are right. Out of 345, we found 41 candidates there are anomalies. They did not have the requisite, but 41 candidates did not have the requisite qualification. So this was then after everything was over, then the court said this is what has been done. They said that opportunity given to us will rectify it and we will bring someone, 41 candidates will replace it. So
In the select list.
yes, this is what they said, 41, and they bought it by way of an application form. There was some interim order which was protected.
I know.
So they brought it by a modification variation of the order that is modified to the extent that 41 should be replaced.
Now, Mr. Das, one query. You completed the whole process of selection.
I completed the whole process, I was not selected.
Okay. Viva and everything was.
Eh,
No. It is not a final select list. It is a select list to, my lord, for interview. These are only screening.
Ah,
list.
that's what
No,
I was.
interview,
This is
This is
screening.
select
Interview.
list.
yes, screening.
This is screening.
Screening,
Interview, yes,
Final-
we have.
yes. So now
That's
my
why I
lord,
just got a bit-
now the particularly the 12 candidates, now they came up before the court and said 41 candidates, yes, you are right. Then said we should be allowed to rectify all this. Again, we should given a chance. We'll do it. So ultimately what it is they found, they could not find. They found 12 candidates. These are 12 candidates.
From
These
bottom
are-
they brought
yes,
in.
They bought it. But what is very interesting, they brought this 12. Out of 12, again, 2 was problematic. We said 2, how can you do it? They said yes, out of 12. Now these 10, we find, this 10, how they have come up, this 10. This is our whole case. How you brought this 12? Because if you have brought this 12,
When
it-
was this process? 2017.
25/5/2007.
How many posts were involved in the original
Yes, original, if you,
Advertisement,
it was, we find 66 post of assistant professor. 66 post, technical.
and,
And
person
and
who
the-
qualified for interview was
25,
345 minus 41,
yes,
304
304,
plus 10. 3014.
yes. Now,
Okay.
now this is the scenario background of this case. Now he came, modification, they said these are
So
12.
if we can just narrow it down.
Yes, now let us say what was our case. What was the point? What was the point before this honorable court?
Mr. Das, as
Yes.
with your
No, go,
opening,
yeah.
you have dealt with everything,
Yes.
and that Mr. Das can only do.
No, I can't.
The issue,
Yes,
if we can just narrow down.
yes,
There was a recruitment process
yes,
wherein certain qualifications were given. You participated because you had the eligibility criteria.
yes,
You went through the selection process, written whatever it is. Then on the declaration of that written examination details, you were directed to appear in all were directed to appear in a language
local
test.
language
Test. You people also appeared in the language test. Now, the persons who have qualified the recruitment process will be slightly more than, will be much more than 345. So they held a language test, screened up people, and then published a list of 345.
Yes,
345.
and this 345 candidate will call for the interview.
For interview. For
Yes,
viva.
yes,
Now, this process by which they have done it after the interview process, after the written examination and the 345 list, there is a language test. So that's a qualifying nature of test,
right.
if I have understood,
Yes,
if I remember. Now, whether this prescription with regard to that that language test would be a qualifying test mentioned anyway.
it was not mentioned in the advertisement.
No need. After that, whether it was mentioned.
Yes, it was by notification that came up.
It was mentioned.
Notification.
Now, in the light of that notification,
Yes,
you participated.
I participated.
So once you have participated by noticing that, whether those decisions that the rules of the game cannot be
No,
changed.
that's not my point.
No,
Yes.
I'm negating
Yes,
my,
yes,
my
yes, yes,
I'm
yes.
negating my.
Yes,
So that issue will not come.
yes,
So we will have to hold that the ALT or the language test, whatever it's there, that was deemed to be a part of the recruitment process, which all agreed.
correct. Right.
Now you go ahead.
Right.
Now, in this petition, how many petitioners are there?
There
All-
are about I just tell you lordship that 19.
19.
Yes.
And this 19 may belong to different disciplines.
Yes.
Now, can you just show me the advertisement?
Yeah, I'll show you. Kindly see the page 27.
Yes, it's with me. I'm there.
Kindly see 166 post of assistant professor
Hmm.
in 9 different subject in engineering college of Assam.
Hmm.
Lordship got it?
Yes.
Now kindly see the education qualification
Hmm.
below. BTech, ME, MTech.
Hmm.
MTech means my lord polytechnic.
Politics.
ME is engineering. Now if you go to page 28. So now my lord serial number 1 for a moment at 27.
Hmm.
BE,
Assistant.
BTech, in civil engineering with first class or equivalent and so and so.
Hmm.
So only in civil engineering,
Hmm.
both should be there.
It says BTech and ME,
ME.
MTech, this together in civil engineering.
Why? Why it is BTech if it is polytechnic, MTech is polytechnic and B is engineering.
Forget it.
So B and ME.
BTech, ME, MTech, this we'll have to bracket it and
Yes.
understand that it is civil engineering.
Yes, correct.
Now, just for my understanding, show me the final that list 345 or the list they have published for language test. Where is that?
But 1 second, my lord. For a moment, if your
Hmm.
lordship kindly, my lord, if you see the 1 second at page 34,
Hmm.
kindly see 34.
Hmm.
Kindly see the written test interview at last bottom.
Hmm.
If number of applicants received is large, the commission may shortlist the number of can either on the basis of the marks obtained in the qualifying academic examination required for the post in terms of advertisement or by holding screening tests multiple choice objective type written set which will be notified in due course. Right, Milo? Now, if you turn to page 35, this is a notification which has been issued, which they declares after the written test was held, OMR, and these candidates qualified. But kindly see, candidates, 4 lines, candidates after 3 lines, candidate bearing the roll numbers are declared to have qualified for the written test on local language of Assam. So the date of written test will be notified shortly.
Okay,
So now,
okay.
for the first time, they issued the notification at page 39, which your lordship wanted to see. This is the notification 23rd of December 2020. Now, kindly inform who have qualified the screening test in more than one post for recruitment to the post of Assistant Professor Technical and Librarian in so and so, which was held, that they will have to appear in language test on local language of Assam qualifying on so and so as per their roll number provided list. It is noted the candidate have to appear in only one language paper for both the post. Kindly note the candidate who opted for English as a local language will have to produce original caste certificate of so and so.
Now, Mr. Das,
Yes.
we have 19 candidates here.
Yes.
And they would be in different disciplines.
Yes.
Now, a person who is competing for the post of civil engineering, can he have a grievance with regard to a person who is there in mechanical engineering? You are going generally,
Yes.
but the page 35,
No, that's absolutely. By the way,
it
somebody
has
have
what
a-
a type.
Suppose I have applied for mechanical engineering. I have applied for civil engineering.
All 19 civil.
One candidate apply for mechanical.
No, I'm not on that. A civil engineering candidate
Yes.
will have to have a grievance with regard to the persons who is there in that civil engineering list. He cannot have a grievance with somebody, correct me if I'm
Yes.
wrong. He cannot have a grievance in view of this. Maybe the posts were advertised together. In view of this compartmentalization now they have made. How can you have a grievance?
No, I'll give an answer.
Ah.
I'll give an answer. But the compartment which they have made, so far as a mechanical engineer, I applied for civil engineering. Basically, I should not have a grievance so far other discipline is concerned. The only grievance when they were selecting, when this is what we made, that your lordship is asking that point, I have understood why you are asking. That's I argued. I placed it before the court.
That's why
Yes, I know. My lord, this is what, for mechanical engineering, you are a screening committee. You are a screening committee. So, for mechanical engineering, you need BE and ME. So, a candidate who is having a BE in civil engineering, he is applying for mechanical.
That's an exception.
No, that's the reason why they.
We got it.
No, that's the reason why they rectified. They 41 they removed.
Mr. Das, now everything is clean.
Oh, yes.
Now everything is
No,
clean.
even everything is not clean. That's why I'm here before
Fine,
this
I'll come
court.
back. But only
Yes.
clear one doubt.
Yes.
Because now the issue would be, what you will be now leading me to is, how could they have that 1:3 or 1:2 ratio that they maintain? It will boil down to that finally.
That is the last.
Last.
First point. Now let us the formula is the enter. The first point will be, my lord, that whether the selection which you have made, which you have done it, selection committee, whether the selection is really whether there is a sanctity of the selection or not. Sanctity of the selection. Because once we argued the matter before the court and placed it and said that this is what you have done it. And they said, yes, it is our mistake. 41 has been replaced. So where is the sanctity of it? Not that.
Mr. Das, just when you're arguing that point,
Yes,
can you also make a submission
yes.
that the irregularity or illegality that is there in the system or in the selection process cannot be severed? It is one homogeneous group which you cannot sever. If not, if that can be severed, 41 have been taken out. That would be saving, because this court would like to save this election if possible.
So let us.
You
let
will
us-
have to lead me
I
to a
know
situation.
Lordship is saying why the non-tainted should suffer.
Who are
Non-tainted,
clean?
non-tainted should suffer. Tainted, but it is not a case, kindly bear it in mind, my lord. It is not a case of a fraud where tainted or not. It's a case of a selection which is made by them on the basis of the qualification, entry into the qualification.
Now,
Is
after
that's
this
why
41
I am
was,
saying
Ah.
the judgment of the Supreme Court in 2020, there is a judgment. Irregularities happen. At large, it should go. But kindly see, this is, they have selected, they have admitted that yes, this is a mistake. And today you are replacing the 12 from where you are replacing. Because those 12 candidates, which you, that's a very interesting point, my lord. Those 12 candidates which you replaced, from where you have replaced, because they stand on the same footing like us. Because they did not qualify the local language test. That's why their name did not, it was in the list of 345 candidates.
oh, Mr. Das, is it a other way around that 345 were brought in
Yes,
and these people whom you say
yes,
did not figure therein like you,
yes.
they did not figure therein because they did not have the requisite marks for that.
They know, the qualifying, that's the whole issue, my lord. My lord, let us may understand, my lord, the advertisement, OMR, let us put for ourselves, we qualified. Now, once we qualified, then local language test. Now, our whole grievance was also pointed out, local language test, you have not notified whether we qualified or not.
That's what my next question.
No, that's what I'm saying. You did not inform us whether we qualified. Because we are indigenous and you think that local language test, because they have done it only to cover up that PRC. I'll show it. That's what their affidavit says. That's why I've given a
That is
reply.
admitted, madam. No need to admit it.
Let me finish it.
That is admitted.
So that's what they want to cover up. No, they did not. That's a stand we say we have taken. You did not notify us whether we cleared the local language test or not. And now,
We'll clarify that.
no,
Mr.
no, one
Otto,
second, my lord. Now, your lord,
clarify one thing. Whether the 19 petitioners or if they are there, they were not called for the interview only because they did not have the marks
No,
or they did not qualify in the,
Yes.
what was the qualifying marks?
No, qualifying mark, there is no qualifying mark, my lord.
You say qualifying?
No, my lord, qualifying mark, there is not a digit mark, my lord. Your lordship can see, we prepared a list.
Ah.
According to ratio, my lord, suppose that we have to maintain the ratio, at least is there, my lord.
I'm not on that. Once they qualified in the written examination,
My lord,
it was
No,
not for
written-
Viva. It
written,
was not for Viva.
my lord.
This page 35 was not for Viva.
Yes.
Normally, it would have gone for the Viva. It did not go for the Viva.
Yes.
It went to a local language
Yes.
test. Now, from there, the next list is being prepared for the Viva.
For the return, the interview.
Viva. Now, today, we ask you, you only picked up 12 candidates, but you removed 41,
41.
right? You removed 41.
Before that, I'll please, my lord. Before
I'm not on that,
your
not on that. Just some query. You removed 41, right? That is after the language test.
No, after the language, your lordship kindly say that's my lord. That is the gap. I'll place my lord. That is the gap, my lord. Where I'm submitting before your lordship. What happened, my lord? We declared a list. These are the candidates. They are qualified for Viva.
Where is that list? Mr.
That
Das?
list, my lord. Your lordship kindly first. Your lordship kindly see that page 35, my lord.
That is qualifying.
Then that page 35. That is they are the person. They are the person go for my lord language test. Page 35. So their name are included in that list. Page 35.
Come to page 40. That
Then,
is
my
the
lord,
interview, Mr.
Yes.
Das.
So
That is for the interview.
yes,
yes,
Huh?
yes, that is for the
That's
interview.
okay.
And that
that 35, I'll just complete.
No.
35 is not for the calling for interview, Viva.
That is for qualifying test.
Yes.
qualifying.
After qualifying test, 40.
Yes.
You are agreed by 40 because
Yes,
your name
that
is
been
not.
challenged.
Mr. Das, Mr. Monto. Forget 35. We have it 14.
40.
Out of this 40, you removed.
No. Then your lordship can see. Yes, absolutely correct. This 40 has been challenged before this honorable court, and this honorable court says that yes, What is that? There is some, their grievance is that they are not, somebody, they have not requisite qualification. So,
I got it.
since they are not requisite qualification, they
You
give us
removed
a
it.
power to examine.
You
So-
made the operation.
Yes.
Cancerous part removed.
Yes, 41 removed. If I remove that, then it is, no, then it is,
Now,
then
that's my question now. Please understand. You removed 41.
41.
So here this list at 40 and 41 is minus 45, 40,
Minus 41.
41. But you re-included only 12.
Yes.
Why?
That is, my lord, answered in earlier occasion also, my lord. Why,
Tell
my
me.
lord, I'm saying? Because after removal of 41, I have to maintain the ratio. I have to maintain the ratio.
Why? Why did
No,
you
no,
maintain?
no. If
You
the- no, no, I-
maintain the ratio here
I'll
also.
come to that, my lord.
Hmm.
If 41 removed, in that place, we have to again include 41.
Hmm.
Then ratio will be maintained.
Hmm.
But when it is subject wise, there is, my lord, in miscase,
That
your
is
lordship
my
find the
question.
list, my lord.
That
That
is
it
what
was
I-
given to your lordship, my lord. In miscase, it is made.
I know. That is what I want.
That's why, my lord,
Now,
some
what
are, my lord,
what was the removal
My-
from each subject?
that, my lord.
It's there somewhere.
I'll place it.
It is there. Then it's
fine.
enough. Yes,
Am I-
Mr. You continue.
My lord, the point which your lordship was asking, these 12 candidates.
Oh,
12
that is in the affidavit,
candidates,
my lord.
12 candidates from where they have picked up and from where they have picked up. That's the issue, where they have picked up. Because 12 candidates, because if you see the affidavit, the picked up of this is everything process was over. When they came to the court, when we came to the court, they said, okay, what we'll do, we'll pick up some 12. From where you are picking up this 12?
Why 12?
Why 12? And from where you picked up? You picked up, okay, fine. You picked up, they qualified. The local language test also. Now you are equating those and you are calling for a viva of these 12 candidates.
Okay.
From where you have called?
Mr.
My lord, for a
Mr.
moment.
Mr. Das,
Yes,
we have page 40 with us, page
Page 40.
41 with us,
yes.
and the orders of this court to take remedial action.
I'm sorry, 40.
Orders of the 40 and 41,
Yes, 40, 41.
that is the list for viva.
Yes, yes, right.
Then the orders of this court for remedial action. Now, remedial action taken, 41 removed. Okay. Now, show me that after the removal of this 41, you ought to come in.
We will not, I mean, that's number one. Number one, throughout, we have been pointing out also before the court that what is the qualifying, why we did not qualify? That's the point. Because they did not inform to us. Because now they are saying, no, we did not qualify. What is a qualifying mark?
Have
We
they
said-
brought that on contention on record?
Let's see, my lord, the affidavit which they have filed, stand taken by APSC.
So the first issue which we have to
Yes,
examine is
yes,
whether this 41, that is by the orders of this court,
Yes.
gone.
yes.
Now, whether that has to be replaced by 41, and if so replaced, if required to be replaced, subject to Mr. Monto's argument on that ratio to be maintained, we'll examine that. If that 41 is to be replaced, whether you will come in
Yes. Now,
or anybody else is
no,
coming in.
41 replaced. Now 41 replaced. Now if you see at page 125,
Hmm.
kindly see at 124.
Hmm.
124 after Annex B.
Hmm.
That the deponent begs to say that the
Just a
accordingly
moment.
commission
Just a
at page 124. See 124 and
Ah,
after
last.
Annex B,
124.
the affidavit which has been filed by APSC earlier. APSC.
Annexure B.
Thus, I don't know why this marking is
Page-
affidavit filed by the APSC.
Yes, yes, my lord. That is,
Why not 124?
yes, page 124.
120.
Page
124 annexure B. is
After Annex B,
Yes.
Not here.
Lordship got it?
No, it's not here.
124, page 124.
121.
Paragraph, you tell me the paragraph.
No, there a paragraph, there's a long paragraph.
But whatever it is.
It starts from, it's a big one. It's paragraph
Paragraph
7,
Hmm.
it's paragraph 8.
Paragraph 8.
Eight.
That with regard
Please-
to the statements made in paragraph 7 and 8.
Please
Right.
turn, please
That is
turn, yes.
Starting is
Correct,
that?
exactly.
With regard to the allegations of so and so, so
Yeah.
and so.
No,
And the
no,
next page is with regard to the second paragraph, with regard to the allegation
with the regard to the allegation,
Huh.
first is a said list is prepared of a candidate who have qualified the local language test
Huh.
and as per the ratio prescribed in these posts.
Huh.
That with regard to the allegation allowing candidate who do not have the requisite qualification as per the advisor and detained to participate in recruitment process, deponent makes a scrutiny of the applicant the exhaustive process as is done in many stages. The candidature of the candidate remain under scrutiny even after the interview is conducted. Deponent further begs to say that the Honorable Court wide order that is passed in the instant writ petition directed the Assam Public Service to verify the respective medical qualification of candidate in respect department where they have applied for. The deponent begs in persons of so and so. Now, Lordship will kindly at next page that goes further. The expert committee after verifying, Lordship got it? Next page, the expert committee after verifying the educational qualification of 345 candidate board assistant for technical found 41 candidate ineligible to appear for the interview. Now, these are the candidates they have mentioned. They have mentioned now. They have mentioned somewhere. They have all they have said. Say how many scrutinized department wise.
So out of
Department-wise.
chemical, civil engineering 47,
Yes. Selected,
number of applications selected 40.
rejected 5.
Rejected 5.
5. So if
So
you
it
see,
comes to total
next is
41.
41, which I said 41. Now this paragraph now kindly see next paragraph. After that, thereafter the commission approached this Honorable Court filing an IA, praying for grant of leave to Assam Public Service Commission publication fresh result of candidates. This Honorable Court wide order dated 6/9/2022 was pleased to dispose by directing the APSC verify the educational qualification of other candidates who are to replace the rejected 41 candidates and thereafter approach the Honorable Court again. On the basis, now kindly see, on the basis of scrutiny and verification of the credentials of the candidates, qualified the screening test as well as written test on language, expert committee found that total candidates qualified to be shortlisted for the interview against 41 rejected candidates. Details of list provided by expert are as follows. Now, if your lordship
Mr.
kindly,
Mohanto,
now,
just a moment, Mr. Mohanto. When you prepared that 345 list, did you not do it by following the ratio mandated?
By maintaining the ratio.
So that was final. Just come back to page 40. I'm sorry, I'm just for my understanding.
Page 40.
This civil engineering,
Madam.
right? We'll
Madam.
only take civil engineering. You have incorporated certain people there. How many? 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6, 7. 6 sevens are 42. 43, 44, 45, 46.
47.
47.
47.
This is by maintaining the ratio.
My lord.
So now in 125, you have removed 5 persons from here. You have 125.
My lord.
You have 125 or 126, whatever it is.
Yes.
You have removed 5 persons.
5.
Now, where is the question of further application of that ratio? You only have to incorporate 5 here because this is ratio maintained. Or
Yes,
is it
we have-
not ratio maintained?
We have incorporated less.
Why I'm asking you, I want to understand
lord,
whether the
Now,
petitioner...
now you have page 123. Your lord, please kindly see.
123, okay.
123.
Hmm.
Civil engineering. Rejected candidate 5. Selected candidate for replace 0. 123, my lord, page number.
What is that? What is that? Something above, we don't, some page number problem.
Yeah. So, my
That's
probably,
civil engineering.
yes.
47 applications scrutinized.
Now that is page.
Tell me the paragraph.
No, your lordship kindly the first table. Same paragraph 7, my lord. 2 pages later. Your lordship kindly see the para 8, my lord. Your lordship kindly see. Para 8 start from 119, I think.
Here 123. Anyway,
Oh,
no problem.
Oh, yes, there is some marking is done.
That
So
is
your
regard-
lordship kindly then, my lord, page 128. 128.
Tell me what it is then. Ah, okay.
Yes,
120.
civil
Details
engineering
of this.
500. There is no candidate to my lord
That's
replace.
what I'm asking. That means you mean to say that the petitioners,
My lord.
are they?
My
They,
lord.
they had qualified in the written examination.
No.
Now the petitioners, were they disqualified in the qualifying test?
Yes.
ALT.
Language test, my lord.
That's what. Language test.
Language test, my
They
lord.
were disqualified.
Yes.
Yes, they are language. They are. My lord, we are preparing the list, my lord.
I'm not on that, mister. What was the cutoff marks in the language test then? What was the cutoff marks?
Language test, my lord, total cleared by the 800.
I'm not on that. What was the cutoff marks? Then only clearance?
No cut, my lord.
Huh? No cutoff marks.
No, cutoff mark is that minimum mark.
Then how can you, if
Minimum-
they are there, how can you deprive them?
No, minimum is there, my lord, but.
That you
but
tell me, what is
suppose-
the minimum? And that
my
they
lord,
have
that
got
is-
below
that is-
minimum.
That is, my lord, it is confidential, my lord. That is, my lord, if you have put in the night, disclose it.
No, that we will want to know. Otherwise,
lord-
we cannot come to a conclusion.
My
that
lord,
They, otherwise, Mr. Monta, the situation would be, say they are at 1,000, maybe, civil engineer. Petition number 1, let's say, civil engineer. He qualified. And the next, he is there. Others all did not qualify. You will have to go down to him, pick him up, replace him at that 345 list.
my lord.
That's the way only you can do it. If you tell me that these petitioners have failed to qualify in the language test, that would be a different ballgame altogether.
All right, I know that, my lord. No, definitely they are not qualified because that's why, my lord, this is prepared. We have not disclosed this. Cutoff mark, we have not disclosed.
You have to, because their rights are now is to be
Even-
there.
No, suppose, my lord, suppose if out of 100, 20 is the 30 is the cutoff mark. Suppose. So suppose the cutoff mark, but he's getting above 30, but according to ratio.
That
method,
is
will
what
not
I am
come.
saying. That is your
According to
ratio will not come here.
So then.
Mr.
that is
Monta,
the-
subject to correction,
My lord,
if you say that this page 40 was prepared by maintaining the ratio,
my lord.
right? 1:3. So you had a X number of posts, you bought in 47,
My lord.
right? Now, you having maintained ratio here, you having taken out 5%,
My lord.
you only have to bring in 5%. And if they have qualified, wherever they are, they'll come in.
Correct. But if there is no qualified person, 5% is there, then we have to keep it blank.
No, that for that you will have to tell this
Yes,
court
that, yeah, that has to
that
be disclosed. Yes.
they were not in the list prepared after the qualifying examination.
That have to take steps on that.
That's the only thing now we
My
have
lord,
to see.
And that I understand.
If
No,
they have,
if they have a case that if
Mr.
after
Monta,
removing that, they
Mr.
are entitled.
Monta, if Mr. Das's, I have asked him the first question, whether you have appeared in the language
Yes.
test without objection,
Yes.
whether it was notified. He says,
Noted.
both we have not posted. Now the question, now still we cannot, on that we cannot. We will have to know that Mr. Das did not qualify in the
My lord.
language. If he has not qualified in the language test, this is the end of the matter. We need not
Then
even
I'll
go
take his
any step further.
Only on that point, I'll take it.
We need not even go a step further.
My lord, and I got the.
If not, if he has qualified, why is he not here? He should be here. And you're the subsequent application of ratio, we will not accept. We will only stick. If you say now this 40-41 was not prepared, then Mr. Das's argument that the whole selection process, there is something fishy, we will have to examine. That's the only issue now. If you can show that Mr. Das did not clear the language test, impossible. So I've seen
My lord.
all
On
indigenous
that point,
people,
I'll take instruction.
all indigenous people. If they have not qualified, then though it's very big
So
question.
even qualified, they are not, my lord.
No,
Well-
no. Mr. I'll give my reasons for that. If they have qualified, they'll be in that pool.
My lord. No, that in some pool they will be there, but in civil engineering, maybe, my lord, there's not there because all are not in the same pool, my lord.
Be
Some
that as it
category.
may. Be that as it may. Wherever they are.
All right, I will take instruction
Because
regarding that.
not
19.
only in civil engineering, you have
Yes, some
in
other
that page,
category.
what- some others
Yes, my lord, we have 41 minus, then we have to replace 41, but there is no 41 candidate.
Okay, don't go by 41. Please don't go by 41. Go by 51-1943. Go by this list. Your 125 list,
My lord.
right? Now, when 125 and 127 are looked into, civil engineering, you took out 5. But you have not brought back anyone. Forget Mr. Das. You will have to show that there was none who had qualified in the language test and were available.
My lord.
They were not, maybe not within that 47. They'll be
My
down
lord,
somewhere.
I'll take instruction. Let me, regarding their 19 position, my lord, I'll place before.
Yes, Mr. Das, I'm sorry, Mr. Das, I objected to that.
No, it's okay, fine.
I just, yes, now you proceed.
Yes. Now, my lord, will interesting if you see the affidavit.
Hmm.
Kindly see the affidavit.
Hmm.
How they brought it. Your lordship is reading that
Hmm.
500 unit, next
Hmm,
page.
hmm.
See the next page, the paragraph. That's why I'm talking about that paragraph.
Hmm.
After that.
A consolidated annex B.
No, you forget this
128.
once concerned, but that a deponent begs to state a record a commission file IA, give a detail of 12 candidates who included in the fresh list after rejection of 41 candidates. The deponent begs to state on receipt of the objection petitioner in respect to candidates from the newly qualified 12 candidates, commission decided to conduct a fresh verification of all the candidates, including the earlier verified candidates, found that from 41, another 15 candidates were ineligible appearing in the interview. It
So
is
now-
also found.
5, 6, 56 ineligible.
Yes, now kindly see, it is found. 2 candidates among 12 newly qualified candidates were also found ineligible. See how they are doing it. Now, this is very next page, kindly see. The expert committee, after verifying the educational qualification of all the candidates, again submitted a fresh list of eligible candidates, commission on 28/11/2022. On the basis of the expert committee, new list of qualified candidates to be called. How can you do it, new list? How can you prepare a new list now? 12 candidates, 12 candidates
You list
ineligible.
after removing the
No,
illegalities.
My lord, the problem is that whether this new list you have brought in, from where you have brought in? This is the issue. Whether 345, they doesn't appear in 345. This candidate doesn't appear.
They cannot.
They cannot. That's why I'm saying. So 12 candidates, my lord, 12 candidates cannot. So
Mr. Das, that's why I was asking.
no, my lord, from where they have brought?
I'm asking you one question.
Yes.
There are different selections you
Yes.
have to cross. First is your eligibility. Then application scrutinized, you are called for the return. You cleared the return. The next hurdle is the LD, language test,
Right.
which is a qualifying nature. We'll have those details.
Yes.
Now, if you have also completed the qualifying, then the interview. For the interview, we will have to give it to them. The regulations also say so. There will be a ratio,
Correct.
particular ratio.
Yes.
1:4, 1:5,
Right.
whatever it is, they'll apply that ratio. And thereafter, we take the matter forward. Now, you came before this court saying, see, these candidates, there are problems. Your thing is that you also want to be interviewed. You also want a recruitment. It's not that you don't want a recruitment.
Yes.
You also want a
Yes.
recruitment, but you want a fair playing field.
Right.
Now, once this list for the interview is there, and you came up in process of page 125, 129, people were chucked off, removed, not qualified, 60 maybe.
Yes.
Now, that has to be replaced by another 60 because page 40 and 41, I'll not take it. Page 40 and 41, we will take that was prepared in terms of the ratio to be maintained. Now, if you have qualified the examination, you are entitled against your subject.
No,
If there is nobody over you,
Yes.
why I have come? Why I have come before this?
just move.
No, correct.
If you have not qualified the language test, that's the end of it.
No, that's a different issue altogether. But the question is that now even the selection process, my lord, why that's why I'm that's why I'm harping. These 12 candidates, which later on they brought.
10 is left.
No, this new list of qualified candidates to be called for interview. So new list of 12 candidates, apparently they were not in the 345.
They were in the pool
So
prior to 345.
345, whether they have qualified, whether they have qualified the local
That we will
language
now,
test, number one.
that we will take a instance.
That's number one. Whether they qualify the local language test or not, we don't know.
Mr. Das, if I may put it in my words,
Yes.
you have list A of 340, you have list A of page 35, wherein you qualified. Everybody who is there.
Right.
So that is the limit now. We can't go beyond that because that includes all the persons who have qualified in the written examination, right? We can't go beyond that. Now, this people who are now being, thereafter you went for the ALP, they have naturally prepared a list after that, right? Once they prepare a list, or whatever they have done, they have made a list of 345. You come here. Out of that list, now I say around 60 is gone from different disciplines. Now, the question would be, your right to be included in that list is subject to you clearing the language test. If you have not cleared that language test, and you now cannot demonstrate that after the page 1, annexure B, that statement, annexure B, after that there is some more error in the list that is now prepared, that's the end of the matter.
No, if now number one, your lordships is indicating, my learned friend, that you have to tell us whether they have qualified or not. That's
One.
what. That's one.
Plus,
Whether
now that
what-
you have pointed
now
out,
what your lordship is indicating.
now that you have pointed out, the persons who have been subsequently included, whether they have also qualified.
So now my lord will kindly see, well, with great respect, I am saying, what type of selection has been done at what level? You tell the court, no, my lord will kindly see that your lordship has, with great respect, I am saying. But is this type of selection is to be encouraged?
Mr. Das,
My lord,
Mr.
I am
Das,
telling, my
there
lord,
are
the,
beyond this
no,
345, wherein there is no allegation. Those people, those students,
no, I am.
they
see,
are
from the very beginning, I said that why the other eligible candidates who suffer. That's how I also know, my lord. I am also aware of it. Those eligible candidates should not suffer. What I am saying is this is your selection process you have done. Or you come to the court and saying, sorry, there is a mistake which you have done. Today also 12 candidates, they are saying newly list of qualified candidates. How can you say the newly list of qualified candidates? That's our whole point.
got it.
Well, let them bring.
Let them bring
notice.
those. Let
That's
them
very
bring those.
important. That's why I'm saying.
That's important.
Yes.
My lord,
If he is not there,
My
if
lord.
he can satisfy,
My lord, I got the point, my lord.
Mr. Monto, now you got to satisfy this court.
yes,
I don't know whether it's legal,
yes,
whether it's required, I don't know.
and
But this is the doubt.
And
One, after the 41, you have removed. You have removed
41
further. You have
so
removed
that is
further.
not selection, my lord. My lord, is
Oh,
a
that is not
qualification,
selection,
my
that
lord,
is
criteria.
inclusion.
Eligibility criteria.
That is inclusion.
Eligibility criteria, my lord.
That is inclusion in the list. Now that 345 you have there, that is after the hurdle of language test.
My lord,
So you can't go beyond the language test now.
correct,
You are there.
absolutely, my lord.
You are there. Now show. One. Need not disclose for this court's
My lord, I'll
satisfaction. Whether they have
Yes,
cleared that hurdle
if
And
clear,
they are in
then
the
what is
court.
their position?
position.
Yes, I got the point. Yes, I'll try to
One.
make clear picture before your lord.
One. Two. Whether the people now you have included 12 plus
My lord,
further, whether they have also cleared that hurdle
my lord.
from 35 to page 40, whether they can come.
My lord, they are clear, my lord. They are in the plan. But they are 800, my lord, clear. They are in the plan. They are in that 800 panel. So from that, we have, my lord, maintaining the ratio, if we call it. And my
Now,
lord,
so,
give the
and
picture.
further, Mr. Mount, I got what you're trying to hint at. Whether there is a ratio also for the language test. For appearing in the language test, there can be no ratio. Whoever cleared the written examination will be in the language test,
Yes,
right? From the language test, a ratio would be maintained. Right? You get my point?
my lord.
Say you had 800 people in the clearing the written test, or 1,000 people clearing the written test. Thereafter, you had, after the ALT, say 600. And amongst that, 100 were civil engineer, 100 your mechanical engineer, 100, it goes on. Now, civil engineering, you have 5 posts. 5 into 3, 15. Out of that 15, we find, no, 5 were not eligible in view of this process. So 5 removed. But you have 100 there. You had only brought in 15. Now serially, you have to bring in another 5.
Another 5.
That's the end of the matter.
Correct.
So for 35, page 40, 41, list will be recast with another addition of 5. Now you are telling me if the petitioner has qualified in the language test and is within that 100,
Yes.
within that 100, you have removed with regard to civil engineering 5 people. Right?
My lord.
You have brought in only
No, there is no replace. There is no replace.
0.
0.
That means
Zero.
in
That means-
so far as civil engineering is
There
concerned,
is none.
that 100 is not the 0. That 100 should be 0 after ALT. That is what you got to demonstrate to me.
My lord. I'll give a clear picture on that.
Tomorrow.
Not tomorrow, it will be not possible. Tuesday, my lord. Can it be on Tuesday?
Tuesday, today. Only one difficult.
Monday also.
Mr.
Monday,
Toto.
nothing.
If this is the position, they have not cleared the ALT, that's the end of the matter. We'll not go for it.
Monday is.
We'll not go for it. Provided Mr. Das
Monday-
can demonstrate before this court. Now
Monday ki-
after crossing of the fire by this list, there still remains some impurity.
My lord.
That Mr. Das shows and will
I did not-
interfere, right? Otherwise, that is the
My lord,
thing.
one just
Yes,
request
yes, Mr.
from your lordship. Then my lordship is asking repeatedly to my learned friend, what is the cutoff mark? Repeatedly, I have noted down repeatedly how many times, but my learned friend
He
is
has
not
not-
giving a clear, what is the cutoff?
That's why I gave Mr.
Yes.
Monto the example of 100.
Yes, that's why I know. That's why our case where we say, what is the cutoff mark from very beginning?
I'll give clear every picture before your lordship. I will let it be on.
And let it be
Let it be-
the last time you are clearing something. APSC is clearing something in this matter before this court. Because much clearances have been done in this matter.
No, my lord.
From the
actually,
word go.
I'm submitting, my lord. Regarding qualification, my lord, eligibility criteria. My lord, these
Difficult.
are the people it is, but you see, there is a technical, the DT is there, my lord, who are the persons? If they have given a wrong picture, what we will do, my lord? Because this panel, my lord, they are examining. Because, my lord, suppose, my lord, in civil engineering, my lord, in other university, naming something different. So that's why, my lord, eligibility criteria.
But
That's
but
why,
one
my lord,
thing-
we try to transfer.
One thing, Mr. Monto, this cannot be done that a civil engineering post which requires BE, BTech, ME, MTech in civil engineering, you bring in a computer ME, MTech into that.
No, my lord, that sometime, my lord, your lordship, my lord, advertisement also that is included, my lord. But sometimes some degree are, my lord, not recognized, my lord, that I cannot know, my lord. That will be difficult. Afterward, we will scrutinize, my lord. Afterward, suppose someone getting a degree
that-
from, my lord,
That provision is there. If
yes,
subsequently
no,
also you
that's why,
find.
my
you
lord,
can-
who are appearing, all are allowed to sit in the examination, and afterward, we are examining it.
So
Sometime-
when do you want it?
My lord, it will be on Friday, because, my lord,
This Friday.
ACS is
Next
not.
Friday would be difficult because the week thereafter I'll not
Friday,
be.
it's
No,
difficult.
my lord, what happened, my lord, actually, that ACS now preliminary exam is going on.
They'll
That's
have to
why
do it.
that this-
They'll have to do it. You get it. Get it on Tuesday.
Yes, Tuesday. Tuesday, let it be on Tuesday.
Because the week thereafter I'll not be.
My lord, I'll try.
Tuesday. But the first thing in that list
At
be-
their picture.
No,
And
the cutoff marks.
my lord,
And
Cut-off
Mr.
in
Monto, if there is no cutoff marks, then 5/0 not permissible.
my lord.
5 is equal to 0 is not permissible. But Mr. D. Das, DK Das, the D. Das, Learned Senior Counsel, assisted by Mr.
K. Mohammed.
K. Monto, Learned Counsel appearing for the petition. Mr. D. Das, the submissions of Mr. D. Das remains inconclusive. Also, list again for further hearing on Tuesday, but after the division bench.
Yes, that's right. I mean, but you
Tuesday,
also will indicate that.
Tuesday, coming Tuesday, date there, na? Also, on the next date fixed, Mr. Mohanto T.J. Monto, Learned Standing Counsel, Miss P. Sharma, assisting Mr. T.J. Monto, appearing for the senior advocate appearing for the APSC, shall furnish, if required, in seal cover,
Fine.
the result of the petition or the cutoff marks as prescribed for the language test component of the selection process, as well as as to whether the petitioner's hearing had cleared the language test segment of the selection process. Further, Mr. Monto shall apprise this court as to whether the candidates who were found to be ineligible and removed from the list as prepared by the commission of candidates for appearing in the viva voce segment were replaced by persons who had also qualified the language test. The said information, if you can give it to me and seal cover.
My lord, can I get a copy of this?
We'll upload it today.
Fine.
Download a copy. Miss P. Sharma, not Mr. Monto.
My lord, Diplo.
If he gets it, you're out. If not, we will have to pay.
But there is, I am telling you, Lordship, there is no cutoff mark. I am telling you. There is
That's
no
what-
cutoff mark.
If there is no cutoff
No
mark, how
cutoff.
can 5 be replaced by 0?
That's what
That's a
we
question.
pointed out. No cutoff. I am deeply aware.
Maybe I'm on a wrong track, but can't help it. This is the query now.
My lord,
today.
it's all right. It will be better, my lord. We try to keep it, my lord, more transparent, my lord.
More
That's what
fire
I-
is required maybe to make it more pure. Little bit more fire. Mr. Das will provide that fire. And Mr. Das, you will have to also demonstrate, subject to this, that after this crossing over from the fire by way of orders of this court or the supervision of this court, still impurity exists. That you will have to clarify. If not, we will direct them to proceed. That you will have to
We
show.
will demonstrate. Still, it requires an interference by this court. Still.
If more fire is
If
required to
fine,
be
more
given, we
fine,
will
yes,
give.
That's right.
But you will have to now, because
No,
that,
no.
that material is not here now.
Let's see, but they'll let them, if they show a cutoff mark, then situation, if they doesn't show cutoff mark, then
That-
no exercise.
Then we'll have to direct them to redo the exercise.
That's.
Item 4 to 7.
Oh, now reversal of rules. Yes, Mr. Chaudhary.
Yes.
For that.
My lord, Cotton College.
Regularization.
My lord, we kindly have 1846 of, no, it will.
850.
My lord, we first have. No, Corona gets to pay.
We have
Yes. 938 of 2020, my lord.
930. Yes, it should.
If Lordship would kindly come to page
I have
20.
not kept this matter spotted.
Okay.
I did not keep it. But I don't know how it has come. This is not the bench. Whether it be proper for me to take it up. Because this is not the bench assigned. That matter I said further hearing. Mr. Chaudhary, it may not be proper.
Even I'm tired also. Just now I came,
Ah.
came rushing from full beds.
Mr. Das is more tired. Hey, ikita matter kyo aise matter? Into patat satat corona iko. Na fix asil, fix to hele. Photo fix korijen. What to fix korana?
Not be proper to.
It would not be proper.
We'll be happy if we take this matter.
No, no,
but it
no,
will
no.
not be
I
proper.
have heard it.
Proper.
Last time Mr. Chaudhary had
That's why I
taken
was
me.
not there. the
Mr.
first time.
Chaudhary had taken me through the issues.
Yes, yes.
And recently, my lord, the judgment has come of Vinod Kumar,
Huh.
where my lord, to a large extent, my lord, Uma Devi's concern has been addressed.
Huh. That may be an issue here. that may have an application here. Provided you can show
Yes.
that your initial recruitment was by
Yeah.
following the UGC.
Advertisement, selection.
No, not only that, Mr. Chaudhary.
Ah.
Sometimes what they do is
The
that,
Supreme Court has said the initial
there is a line in
appointment,
that judgment.
initial appointment will not determine.
no,
the
there
place.
is a line there. You check up, there is a line there. There is a line, somewhere it's there, that they were appointed by following the process that is required for a regular
No,
appointment.
my lord. It says continuous service of appellant in the capacity of regular employees performing duties indistinguishable from those in permanent posts and their selection through a process that mirrors that of a regular recruitment.
Very good.
That
That's
mirrors that of a regular.
why I'm saying
Ah.
so. UGC recruitment, regular recruitment has a particular selection process, a committee.
Yes.
If that also you satisfy,
Here also, my lord, there was a proper advertisement.
no, I'm not on that. The advertisement, because they went for a contractual thing in
Yes,
your case.
yes.
If
contract.
they have made a shortcut somewhere,
Ah.
then whether this will mirror. That's a question this court may be asked to call upon. Why don't you file a small affidavit on that point also,
We'll do that.
showing that the normal selection, this is the selection committee, this is the selection process. My thing, this paragraph so and so.
We'll do that. We'll file an additional affidavit.
List this matter before the appropriate bench. Registry is directed to list the present matters before the appropriate bench. Also, item number 4 to 7.
Deeply obliged. Deeply obliged.
Item 8.
ऊपर वाला जो लिखा है ना, उसको hurting part.
Please, the lordship.
This also, did I keep it parted? No.
No, lordship, as per the last order, certain documents are supposed to be produced regarding the norms and procedure as to how the
Let it come up before the normal bench. This I'm not kept it parted.
lordship.
Same order.
Item 9.
May it pleases your lordship. Here, your lordship, we have filed our affidavit. I'd like to take you to the page.
List this
51.
matter before, same order. This cannot be because I'm not the bench two now.
Yes, sir. Much obliged, Your Lordship.
Item 10.
Parted doesn't use.
That should be a file or affidavit today.
No. This is also same thing. I cannot take it up. This is not bench two. I don't know why these matters have come. Same order.
Item 13.
Deeply obliged.
This parted doesn't use.
No, it was parted by, 25/4, I think the order did it.
Okay. Okay, this I think. We'll just finish up the list and then come back.
Fine, ma'am.
14.
Orders, item 14.
Lordship, in this matter, they were directed to file.
No,
affidavit.
Mr. Bhagwati, whether I can take it up, whether I should take it up. Again, same thing. It's not a part of matter. It should not come before you. List before the appropriate.
Kindly, my presence may be recorded, your
No,
lordship.
I'll not do anything.
Huh?
I'll not do anything. You show them this. If you show them your today this clip.
Deeply
16.
But in this matter, one the issue is one regarding skill managing committee, your lordship ne, come to your lordship's earlier order. That order is, my lord, we find 1st of April, my lord.
No, same thing. Before the appropriate bench. Let it go before the appropriate bench. Same order.
Lordship में fix a date. Fix a date.
Court will that registry will do. A लिखो list सब में लिखना listed before the appropriate registry is directed to list the matter before the appropriate bench on a date to be fixed by. Oh, sorry.
Item 13.
Yes, sir.
Hello, on the last occasion, I gave one write-up
Hmm.
which contains the,
34/2024 item.
yes, my lord, it starts like common procedural illegalities.
Yeah.
So here, my lord, in the first page,
Hmm.
I gave before your lordships what are the common illegalities committed in the proceeding
Hmm.
with respect to all the charges.
Hmm.
And page 2 onwards, my lord, I have given
Specific charge
individual,
wise.
specific, and I have tried to refer to the relevant page from the record also.
Hmm.
Because your lordship was pleased to give me that liberty.
Hmm.
And accordingly, my lord, I sat with my learned friend
Hmm.
and got the details from the records and page
Hmm.
numbers.
Hmm.
So if I press this, my lord, I think that will be
That will-
sufficient.
Let us go to page number 2 first. Charge wise.
Yes, my lord. Lordship will simultaneously kindly take the enquiry report. Because
Okay.
that has to be referred to, my lord. Lordship also like to take the records.
We'll have it when
Yes,
we
yes.
come that way.
Yes, my lord, my lord.
Enquiry report is at page.
Page 102.
Okay. Hmm. So we are having charge number 1.
Yes, I should have given your lordship the charge sheet because I will be arguing that those were not the charge.
Page 60.
Page 60, my lord.
Hmm.
Yes.
Let us
Or
have that
better 61,
imputation.
my lord. Imputation of misconduct.
Hmm.
Now, the charge was that
Hmm.
first annual athletic meet for the season 2022-2023
Hmm.
was rescheduled due to ATC
Hmm.
and IPSC.
Hmm.
And you were informed to conduct the event at a later date. You failed to conduct the competition.
Hmm.
So basic ingredient is that you were informed
Hmm.
to conduct the event at a later date.
Hmm.
Now, my lord will kindly come to the enquiry report. All sorts of irrelevant and new things are said in the enquiry report, going beyond the charge.
Now, if you come back to page 61,
Yes, my lord.
the allegation is article of charge number 1, failed to conduct the annual meet for the academic session 22-23, right?
Yes, yes, ma'am.
Now, if you come to the statement of imputation,
Yes,
it says annual athletic meet for the session 2022 was rescheduled
yes,
due to ATC and IPSC,
yes.
and you were informed to conduct the event at a later date.
My lord, page 60, if we go by page 60, my lord, there is nothing against me.
Forget it, we'll read it
So
together.
that's why, my lord, I am taking a more detailed version of them, trying to take a more detailed version of them in page 62, 61.
That's what I'm saying.
Yes,
Even in page 61,
yes,
Kushuva, you will go to Kushuva state.
yes,
Page 61, because finally the inquiry report says that there was a date coming up now.
yes,
But in the allegation, in the statement of imputation, it says at a later date.
later, unspecific,
Unspecific. That's what I'm trying
Vague.
to understand.
Yes,
It's
yes.
vague. There was no
Absolutely.
date given.
no date given, absolutely unspecific. That shows that this Kushwaha and other things that are afterthought. Bringing Kushwaha, asking him to say, you say this. And I have checked the records. There is nothing, no signed order.
Now let's go to the
Enquiry,
inquiry.
page 102. Findings. The charge teacher has accepted that he did not conduct the annual athletic meet for the academic session 22-23. Absolutely wrong. The board also found that in spite of being very well aware of the date already promulgated for conducting annual athletic meet, the charge teacher did not conduct it even after rescheduled dates were informed to him by Mr. A.K. Kushwaha.
So this is
the genesis.
the
Mr. Kushwaha has explicitly stated that the events were rescheduled after approval from principal, and each and every teacher in charge whose dates were rescheduled were informed. The charge teacher failed to conduct the event on rescheduled dates, whereas all other in charge could finish their events as directed. The charge teacher neither approached to authority for cancellation of event, nor he informed anyone about the non-conduct of such a major training event. In fact, charge teacher preferred to remain silent till he was show cause. The board also noticed that the claim of non-availability of dates to conduct the events on rescheduled dates have been found invalid. Following points are submitted with regard to non-conducting of ATM 2022-23. The rescheduling of annual athletic meet along with some other event was done for session 22-23 from 10 January 23 to 13 January 23. There were no exams or other planned events on these dates from 11 January 23 to January 23. It doesn't say 23 January 20. It's wrong, Miller. It's wrong. No permission was taken to cancel the event from principal. Individual himself decided not to conduct it and remain silent. This was not the charge. Teacher's claim of no intimation was given to him about news dates for ATM has been found incorrect. As per board finding, teacher was aware of the rescheduled dates of ATM 2022-2023. Individual also claimed that he was not aware that he was the teacher in charge for annual athletic meet 22-23, and he only had come to know when school diary was issued on so-and-so. The claim of teacher has been found false as an ION so-and-so march was already promulgated and later circulated in academic WhatsApp group in so-and-so by Mr. So-and-so on direction of senior master, which was already been seen by the
What
charge
is
teacher.
this inter-office note? ION?
This ION this is not connected to the present charge. This ION was before the session that calendar comes. So this ION was issued scheduling the events in the calendar. So this is not the charge. This is during the course of the hearing, perhaps he was asked question whether you were aware of the original date or not. Perhaps
there has to be something scheduling an event, because the allegation against you is the event was rescheduled, but you did not hold it in the reschedule.
Exactly. So
Now tell
scheduling
me
is
from
not
the
in question.
record,
Yes.
what is that material
Yes.
which they relied upon
Yes.
for the purpose of establishing that the event was rescheduled on a particular date?
Yes, Milord. Lordship will kindly come to this thing, Milord. My write-up. Milord, very briefly, I try to. Milord,
No, it's okay.
explain the thing,
We'll
Milord.
have that
Yes.
details.
Elaborate thing your Lordship will find in my written statement and all these things, reply to the inquiry report. The issue for determination was as to whether there was any in-sign order material before the inquiry committee to derive conclusion that Sri A.K. Kushwaha ever informed the charge officer about the rescheduled dates. The record contained only a mobile screenshot of one text message containing rescheduled dates, but there was no ink-signed order or document available in the records to prove the factum of intimating the rescheduled dates to the charged officer. Even there was no evidence to prove that that text message was sent to the charged officer. At question number 11, page 58 of records, Milord, this I am referring to the records. Mr. Kushwaha was asked whether he informed the charged officer
He answered yes. But in question number 13, he was asked about the date of intimating. He responded by saying he does not have and does not remember. And the screenshot is there. Only the screenshot, mobile screenshot, Lordship will
No,
find it difficult to
Mobile screenshot, WhatsApp.
WhatsApp.
Whether any material to show
No.
that it was delivered.
No, nothing has been. Only screenshot, perhaps that was taken from Kushwaha's mobile. Even Miller Lordship will forget about screenshot. If you have scheduled the date by publishing an ION, what prompted you not to issue an ION and reschedule the date? That is wrong on your part.
No, we will not go to that extent because we are
That's-
only confirming concerning the charge now. That is
Yes.
there.
So
We will only say, we can only look into one fact, whether
there was any.
there is any material to show
Yes.
that at least verbally,
Yes.
also you were informed that please have this event in the, because the principal wants it on the particular day.
Exactly.
Because why I say so, if you can come back to page 103,
Yes. Parameter.
103, Roman small 2.
Yes.
No permission was taken to cancel the event from so and so.
Individual himself decided not to conduct and remain silent knowingly.
So this will come into effect once they can demonstrate that this was given.
This was never a charge.
No,
Yes,
this cannot be a charge.
that cannot.
But if they had given you
Yes,
that intimation, then this would be one factor against you,
yes,
right?
yes, ma'am.
To advance that theory, they can go to this level.
Yes.
Now tell me the response in the affidavit with regard to this.
Yes, madam. It's page 177.
Hmm.
The petitioner has accepted, it's a replica of the inquiry report, my lord, and the entire affidavit is. The petitioner has accepted the charge number 1, i.e. failed to conduct annual athletic meet for the academic session so and so. It is submitted that the charges have already been accepted by the petitioner. During the course of the inquiry, it was also found that in spite of being very well aware of the promulgated dates for conducting annual athletic meet, the apprised did not conduct the event. Even after the rescheduled instructions received from Sri A.K. Kushwaha, after approval from principal, neither he approached to authority for cancellation of the event.
So this is a development. So this is with regard to charge number 1.
Charge number 1, nothing.
Mr. Submissions, खाली ये draft होगा ना? Submissions of Mr. H.K. Das. Article of charge number 1. Mr. H.K. Das, counsel appearing for the petition by referring to the charge, to the show cause. This is called a show cause notice or memo?
It's a charge.
Page 60, what is it called?
Page 60 is charge sheet they told me.
Charge sheet. So
Yes.
the charge memo will say, charge memo
Yes, ma'am.
contains that article of charge as framed against the article of charge number 1 framed against the petitioner pertains to the failure on his part to conduct the annual athletic meet for the academic session 22-23. Also, Mr. Das, by taking this court through the statement of imputation of misconduct pertaining in connection with the article of charge number 1, contents that therein it has been highlighted that the annual athletic meet for the session 22-23 was rescheduled due to APC and IPSC, and that the petitioner was informed to conduct the event at a later date, but he failed to conduct the same. Mr. Das submits that both in the article of charge number 1 in the charge memo, as well as in the statement of imputation with regard to article of charge number 1, there is no disclosure of any particulars as to when and by whom the petitioner was purportedly informed to conduct the event at a later date. Mr. Das further contends that the prescription therein as to the conduct of the event at a later date is so made without a reference to any such date being made therein. Mr. Das thereafter takes this court to the finding of the inquiry officer with regard to article of charge number 1 and contents that a finding has been recorded therein basing on the statement of PW.
There is no PWD. Kushwa, AK Kushwa.
Well, how is he? How is he indicated? PWB, what, how is
No,
he?
by name, he has been indicated
By
by
name.
name.
By Mr. AK Kushova. क्या लिखा है? Recorded in therein, basing on the statement of Mr. AK Kushova, that the petitioner was informed by Mr. Kushwa about the rescheduled dates after the approval of the same was taken from the principal, and further that each and every teacher in charge whose dates were rescheduled were also informed. However, it was contended, however, a finding was recorded that the petition failed to conduct the event on the rescheduled dates, whereas all other in charges could conduct finish their event as directed. It was further further finding was recorded by the inquiry officer that the charge teacher neither approached to the authority for cancellation of the event, nor he informed anyone about the non-conduct of such a major training event. Also, Mr. Das, by taking this court through the findings of the inquiry officer with pertaining to article of charge number 1, has submitted that no material is disclosed in the said in the findings as recorded by the inquiry officer of any ION being issued after the rescheduling of the events and proclamating the new dates. Also, Mr. Das submits that the finding as recorded by the inquiry officer that no permission was taken by the petitioner from the principal to cancel the event, and he had cancelled the same basing on his own. Cancel the same on his own, is not sustainable in as much as they said finding is not preceded by a finding recorded by a conclusive finding recorded by the inquiry officer that by way of a particular document the petitioner was communicated about the rescheduled dates coming into operation. Anything more?
Nothing, that's all.
Then article of 2. This is helpful.
Yes,
This is helpful.
this is helpful. it's got incorporated into black and white when it is fresh.
Fresh, and then when I do it, I'll only have to,
Yes.
it'll be double work for them, can't help it.
Now, charge number 2 is, my lord,
You have failed to implement the Atal Tinkering Lab in a
as a presiding
reasonable
officer of
timeframe.
the board convened for implementation of Atal Tinkering Lab, you kept on delaying the matter and even stopped giving regular update of the progress. Now, charge is you failed to implement the tinkering lab in a reasonable time. Now, charge is different, statement of imputation is different. Fine, my lord.
We'll do it
We'll
together.
take it as it is.
It's together it go.
Fine, my lord.
As a
Yes.
presiding officer,
Now-
you have kept on dealing the matter and even stopped giving regular updates on the progress. Okay.
Yes.
Hmm.
Now.
What is the finding?
103.
Oh, उसमें inquiry officer का जो लिखा है ना 102 में तो लिखा है ना finding जो सामने लिखा है 103 हाँ
Yes. The findings, Miller. The charge teacher has accepted that he failed to implement the auto tinkering lab in a reasonable time frame. As per board's findings, implementations for ATL board was constituted by ION number so and so dated 6 October 2022 to submit proposal for setup of ATL by SHG by 20th October. Mr. Sengupta was presiding officer of the board along with the charge teacher, G. Deka, and Mr. S.M. Rahman were the members of the board. The board did not submit its report by the due date and remained silent on the same till the BOI found it during the inquiry. The board was supposed to submit its finding by 20th of October. On a reminder by senior master on 8 November 2022, the charge teacher submitted a minute sheet consisting of equipments of ATL with 4 packages. Board found that no reasonable work was carried out by the previous board till the board was charged on the request of the changed on the request of the charge officer on 10 November 2022. Milord, prior to this, these are previous past things. In past, there was a board by this Sengupta, charge teacher and SM Rahman, and that was not done. The ATL could not be established then, and thereafter, it was changed on the request of the charge teacher on 10/11/2022. So new board was formed with the charge officer on 10/11/2022. Charge teacher approached the vice principal before 10 November 2022 and requested to make him the board president for implementation of ATL at school. He vouched that I'll implement the ATL in the school. As he did not want some other teachers to take the credit share of implementation of ATL at school. And that has, Milord, gone against me since I took the initiative. Become the teacher in charge for the ATL. His request was accepted and another I-1 was issued to Mr. D. Kundu as only member along with the charge teacher as presiding officer with reference to earlier board made on 6 October 2022. So new board was formed. Following major points have been observed by the board for failure for the establishment of ATL tinkering lab at school. There was no final date of submission mentioned in the second ION. Second
that
ION
means second ION.
means 10 November.
Okay. Where do you get it?
It says the charge teacher on request, till the board was changed on request of the charge teacher on 10 November 2022.
Okay, this was changed
Oh.
with this ION.
There was an ION on 10 November 2022. There was no final date of submission mentioned in the second ION. However, the date submission was mentioned in the earlier reference ION.
So,
That date has already been over. The charge officer took the advantage of the same and did not inquire the school authority for the date of final submission for the board and preferred to stay silent on the same. So you will not mention the cutoff date in your ION and you divert the letters or sentence in this manner that I took the benefit. I purposely did not do. Board also found that 2-3 months time is a reasonable time period for implementation of ATL. The board now finds in any institution if everything is planned correctly and made available. through the statement of charge teacher and Mr. D. Kundu, however, charge teacher failed to even upload the RFP today. Milord, RFP was already uploaded. Charge teacher as BP failed to make any
What is
action.
BP?
BP is board president. Failed to make any action plan or decide definite timeline to complete the board in a reasonable time. The charge teacher failed to communicate regularly with the members, with his member teacher, Mr. D. Kundu, and work all alone on the project. Charge teacher also failed to give weekly update on the progress of work to authority, even after the clear order from the principal. Charge teacher waited for approx 3 months for response from only single company, MS Tamrobo, without any valid justification for waiting, and wasted 3 months' time. ATL lab has not been established in Sainik School campus till date. So this is the finding. Now, if your lordships kindly take my write-up. In point number 1, the inquiry committee found fault with the charge officer for absence of cutoff date in the ION dated 10/11/2022 issued by the principal, and proved that charge officer took benefit of non-mentioning of cutoff date. In point number 2, the purported 2-3 months reasonable time was aspiration of the inquiry committee. Failure to upload RFP was not the charge. Both 1 and 2 were not the charge. Similarly, 4, 5, 6 were also not the charge. There was no misconduct on the part of the charge officer. What was the charge, my lord? If we read again,
Where?
it says, as a presiding officer of the board convened for the implementation of auto tinkering lab, you kept on delaying the matter and even stopped giving regular update. So that was the charge. These facts, these points, my lord, recorded by the inquiry officer, inquiry committee, 2-3 months. I fail to mention.
Go through B.
Yes.
B and C.
Yes.
Work was done by.
Work was done by charge officer as part of the board, but no action against Mr. D. Kundu. Therefore, decision to proceed only against charge officer is discriminatory. B, my lord, it would have been C, my lord. In point number 3, although non-deciding of timeline was not the charge, but the charge officer effectively narrated the steps taken at paragraph 5 of his written statement of defense, page 66 and 69 of WPC, my lord. And paragraph 2 of his reply to inquiry committee's reply, page 113, 114. Finally, the final RAP was submitted by the board comprising of the charge officer, and it is lying with the office for sanction of money to implement it.
Now, when was it?
July
submitted?
2023, final RAP was submitted.
And why was the delay?
Thereafter, they are not.
No. Because
The
you were
explanation,
constituted-
yes,
You were constituted on 6/10/2022.
yes.
You took a year,
It was constituted on by ION dated 10/11/2022.
22.
Then
Okay,
explanation, your lordship will find page 66 of
Okay,
the
that-
writ petition.
okay, fine. Now tell me.
Detailed description
No,
has
tell
been
me.
given.
No,
In fact,
fine.
the
We
details
got
of
it.
tax
We-
message was also
We
given.
got it.
Yes, my lord.
What is the basis of the inquiry officer's conclusion? From the records?
My lord,
Who were the witnesses here? What was the document relied upon?
nothing, my lord. Lordship will say absolutely on the basis of conjectures and surmises. My lord, they have,
No, with regard to article of charge number 2,
yes,
to bring on record before the inquiry officer that it will only be 3 months time is required to implement this. Who made that statement?
no,
Who?
it said, the board also found there is nothing on record.
No.
It's the understanding of the board.
Understanding of.
Yes, this can be implemented within 2-3 months' time.
No witness.
No witness, nothing.
Okay. So Kundu was examined.
D. Kundu. Those statements are.
Mr. Khan, just check up
No,
whether.
just, Lordship will give me a second, my lord. Page 95. Kundu was examined.
Hmm. What is his statement?
Page 95 of the records. my lord.
Yes, Miss Gan, just give him the records. Page 95, what is the statement?
Hmm.
95, just read what is it?
There was an ION issued for implementation of IPL in school. Are you aware of it? Yes. As per ION, when you were supposed to implement or complete the board, submission date is not mentioned. Date is mentioned in
Okay,
reference.
submission date not mentioned. Kundu.
Yes.
Hmm. Submission of RFP,
Yes,
Yes.
huh?
yes.
Yes, ma'am.
RFP not mentioned, okay. Then,
Date is mentioned in reference, referred in the ION. I have not got the reference letter, whatever I could recall.
no. The of reference pertaining to the earlier ION, that means
Earlier, yes.
received by. Then,
What have you done as a member? The board was existing from before only. Mr. Z Decker was doing the work. The PO was doing the communication with the authority. I was helping him.
Hmm.
How much time does it take to implement ATL in a reasonable time? Sir, 2 to 3 months depend on how you can get the item.
Hmm.
How many months have passed after date of issue of ION? Almost 11 months delay.
Hmm.
Do you think only PO was responsible to the authority?
Hmm.
Since he was taking the information from authority.
What, read again?
Since he was taking the information from.
The question.
Question is, do you think only PO was responsible to the authority?
Hmm. You means the,
PO means this.
should be C.
PO, minus PO means.
PO, it should not be PO, it should be CO.
CO.
PO. No, the word is PO. Several times it is written.
Read the next question.
How many times meeting was conducted to finish the assigning work? No meeting was conducted. However, we had discussion.
Then?
Where any timeline, deadline were decided to complete the task in time? No.
That much only. So,
I stand corrected, my lord.
that 2
from-
3 months thing has come there.
Come from Kundu. And so far as I am concerned, my lord, whatever steps I have taken, page 66 to 69 of
There,
WPC.
it is there.
I have given in details, date, time, text message, everything, and
Nothing.
nothing was considered during inquiry.
Mr. Pusa, with regard to article of charge number 2, Mr. Das submits that the same relates to allegation leveled against him that he had failed to implement the Atal tinkering lab in a reasonable time frame. Pusa, they said article of charge was read in the context of this, the statement of imputation of misconduct was read in the context of the said article of charge number 2, and it was contended by Mr. Das that in terms of the same, it is the allegation against the petitioner that being the presiding officer of the board convened for implementation of Atal tinkering lab, he had kept on delaying the matter and even stopped giving regular update on the progress thereof. So, Mr. Das, by taking the scope to the findings of the inquiry officer as available in the inquiry report against the said article of charge number 2, submits that the same brings to the forefront that the board in question was existing from 6/10/2022 and thereafter, the same not being functional, the authorities had issued an ION replacing the said board with a board having the petitioner hearing as its precedent for implementation of ALT in the school. Also, Mr. Das submits that the conclusions as reached by the findings as recorded by the inquiry officer in this with regard to the article of charge number 2 were clearly biased in as much as the materials brought on record by the petitioner in connection to his stand with regard to article of charge number 2 bracket mein karna available at page 66 to 69 of the petition bracket close were never given, were not considered, and basing on the statements made in the matter by Mr. D.K. Kundu, a member of the said board, the broad findings came to be recorded in the inquiry report. Full stop. It is contended by Mr. Das that a perusal of the statement made by Mr. D.K. Kundu in the matter would reveal that on a question being put as to the period it would be reasonably required to set up the lab, Mr. Kundu had submitted that the same can be set up within a period of 2 to 3 months. However, it was with a further clarification that such period of completion would depend on how the items are procured. So, Mr. Das further submits that on the RFP being prepared, the same was submitted before the school authorities in the month of July 2023. However, till date, the same has not been approved and the amount requisite for setting the lab in terms of the RFP has not been released in the matter. That's it.
Yes, my lord.
Next.
One more aspect, my lord. At the very beginning, the charge itself is vague and indefinite.
Mr. Das, Mr. Das at the outset submits that the said charge is vague in as much as the same does not disclose any particulars of the allegations as now leveled against the petitioner. So it is the contention of Mr. Das that
No time limit was fixed.
It's the contention of Mr. Das that the ION allowing the petitioner to function as the president of the said lab, a committee to set up ATL had not prescribed any outer time limit for completion of the works involved in the setting up of the said lab. And accordingly, he submits that the charge being vague to the core of it, the same ought not to have, the same cannot be proceeded against and basing thereon penalties imposed upon the petition. Yes, next.
Yes. Now we come to charge number 3. It says being an in charge of IH obstacle competition, you failed to conduct the event in a befitting manner.
Just now.
Page 60. So I again come to the word I'll have on befitting manner, my lord.
Being in an in charge in the so and so, you failed to conduct.
So it's not that I failed to conduct.
ICH was conducted in an unprofessional manner. The event was eventually declared
Cancelled due to the integration of cadets and mismanagement by the in charge.
Misbehavior of candidates was also during that photograph.
Yes.
Being
So finding
in charge of IH obstacle competition, you failed to conduct the event in a befitting manner. Okay. The IH obstacle construction was conducted in a unprofessional manner. The manner was eventually declared cancelled due to indiscipline of cadets, mismanagement by the HR, behavior by cadets was also not so and so. What is the finding?
Yes, finding you'll also will find. at
Page 104.
Page 104. IELTS obstacle competition for session 22-23 was scheduled on 23 November 2022. The general instruction for the same was promulgated in part 1 group on 18/11/2022. The child teacher remained absent from school when the part was published on 18 November 2022. The GI for the competition for publication in part 1 was given by Mr. Sanjay Deka. The charge teacher had handed over the draft of GI to Mr. Sanjay Deka to publish in part 1. The board has found that the charge teacher was the overall in charge of the event and publication of GI for the event was his responsibility. However, charge officer left the school on 16 November 2022 without publishing the instruction. Board has found out the event was mismanaged and poorly conducted by the charge officer. You know, this charge officer left the school on 16 November. I was sent to IPSC in the next charge that's come. So that is related to that. The following points are submitted in support of the board's finding. The event was initially planned to be conducted on 25th November 2022 as per the term calendar. However, in one the academic meeting, the charge teacher had approached authority to conduct the event on 23rd November instead of 25th November by stating the reason of non-availability of class 11 on 25th November 2022 due to their NDA tour. The charge teacher failed to conduct the meeting before publishing the general instruction and left the school on 16 November 2022 without informing Sanjay Deka about the meeting, which should have been conducted before finalizing and publishing the GI in part 1. In his reply to charge sheet, he has mentioned about shortage of manpower, including 6 teachers, as the main reason of poor conduct and indiscipline of cadets during the event. However, after comparing with the attendance register of so-and-so and general instruction of last obstacle competition 18-19, board has found that there was no shortage of manpower sheet attached. Additionally, charge teacher failed to approach the reprise authority about the shortage of teacher and continued with the conduct of the event. Therefore, his claim of shortage of manpower and teacher have been found invalid by the board. After cross-examining from Mr. P.K. Odhikari, S.M. Roman and Sanjay Deka, it was found that the event was not conducted in befitting manner. Board also found that P.K. Odhikari and other senior housemasters were not assigned any duties during the conduct of event. They were not assigned duties to look after their respective houses during the event. As per the board understanding, if housemasters are given no duties, then there should have been no case of indiscipline by the cadets. However, the incident of indiscipline took place. Therefore, board also found that the housemaster of the erstwhile senior house should also be held accountable for poor conduct of event along with charge teacher as he failed to conduct the briefing of housemaster and cadet before the event. IELTS obstacle is a major event which involves all teaching staff, admin, general employees of the school. As per school working ethics, coordination is always conducted before the actual conduct to inform all involved personnel about their role, responsibility, and rules of the event. However, charge teacher failed to conduct a coordination meeting before the event, which led into finally cancellation of the event. The charge teacher has accepted his failure in conducting coordinating meeting. Please refer attached statement. The charge teacher has also accepted his failure as overall in charge of the event. Please refer the statement attached. Both found that the event was not conducted in a befitting manner. So, what was the charge? Charge is failed to conduct in a befitting manner. And they have said everything in this finding, Milord.
Event was eventually declared cancelled due to indiscipline of cadets.
I did not cancel.
They
When
cancelled.
Milord, what happened here? Milord, one batch of students of same class were lacking behind. So one batch of students to boost up their morale use unparliamentary word. This has come in the thing. So that was heard and it was informed to the vice principal informed to the principal, and taking clue from that, Milord, they have framed this charge. I have explained in my written statement as well as reply to the inquiry report.
Now, what is this cross-examining of three witnesses by you? Odhikari, Roman and Sanjay Deka?
PK Odhikari, SM Roman, I never, one second, Milord, just give me a second. No, Milord. I only asked question Kushwaha and one H. Ali. Those were never cross-examined.
So this is basically the examination that they are
Yes,
projecting.
this is, yes, Milord, this is examination by the committee. So my answer here is,
Okay. This is all ocular evidence, or there is any written evidence or documents to establish this charge?
no, Milord, there was no,
It's
I have
all ocular.
only,
Okay, now that was cancelled in 23 November.
yes,
Okay, no, it was cancelled it was held on 23 November, right?
yes, 23
What
November.
was the immediate reaction in this matter from the authorities to you?
No, they have issued the show cause notice,
That was issued on?
23, my lord. My lord, I was given back-to-back show cause notices, 6 notices, which form part of these 6 allegations.
No, for this allegation number 3, there was a separate show cause notice given to you.
Initially, but not immediately.
When immediately, forget the show cause, what
No.
was the reaction?
My lord,
When was that show cause given?
show cause was given, I'll just check. It was given
Immediately.
December, I think, my lord. I'll just, my lord, check and I'll just inform the date.
Okay.
No, here, my lord, Lordship will kindly appreciate one thing. Lordship will kindly come to my write-up, my lord. Point number 1 to 9 were not the charge, apart from the fact that the whole charge was vague and indefinite. There was no misconduct on the part of the charge officer. However, the charge officer gave befitting reply in para 3 in his reply to the inquiry committee's report, 114 and 115.
What are the statements of this 3? Roman, have they brought on record these materials to substantiate the finding?
Page number mo po
103.
Roman,
PK Odhikari.
103 to 104, 105, 106 and 107.
Yes.
That is your Roman, Deka and Odhikari.
Sanjay Deka and Odhikari.
What is the statement of Roman?
Roman,
Hmm?
who was in charge of inter-house obstacle competition in session 20 to 23 last year. Last year, Mr. Z Deka. What was your role in conduct of event? My duty was in Burma Tower. What else? Were you responsible for something else also during the event? No, sir. Who was the in charge of prize distribution of inter-house obstacle? I cannot remember. As per Part 1, Order 18 November 2022, you gave the responsibility for certificate and trophy. Yes, cannot recall. Burma Tower of Hanging Bridge. Can you recall? I can recall because I have done duty at Burma Bridge or Hanging Bridge as far as I can recall. As per your record, you are not in the hanging balance Burma Bridge. Mr. Goda was responsible for it. Your duty was in certificate and profit. Did certificate and
That's okay. What is
Yes.
against him?
against him, my lord? Any indiscipline during the event? Teacher kept quiet, no answer by SM Rahman. As per our record, you were responsible. No, this is not against it. This is of SM Rahman. Then Sanjay Deka.
Sanjeev Dek.
Also,
What is it?
Mr. Deka, you are aware that there is an inquiry going to that conduct for interview. Who had submitted GI for public. who had submitted the GI for publishing in the Part 1 order of IH obstacle for the year 2020-23 general instruction. I had prepared the in consultation with Z Deca because he was on TD on that day in telephonic conversation with him, and it was published on 18.
Mm.
Did you give your draft before going for temporary duty? Yes, sir. He had given me the details of the entire course.
Mm.
Who had directed you to help him? There was a meeting held before, and he left for TD in the meeting. Vice principal told me to assist him. Meeting means actually Mr. Z Deca raised one problem in one of the meeting that he was going for TD and need to a helping hand. Then VP had proposed me to help him.
Mm.
Did Mr. Gautam Deca ask you to conduct the coordination meeting for the IHU obstacle competition? He did not tell me anything about that. Was IH obstacle event was conducted in a befitting manner? Behavior of the cadet was not up to mark. That is why it was cancelled. In the meeting, only request for helping teacher was requested, or other request was also there. In the same meeting, he had raised a point, preponed the event because cadets of class 11 were going for a NDA tour. That is the statement of Sanjay Deca. Then another is PK Odhikari. Did you present during the IH obstacle competition? Yes. What did you observe? The event was conducted in a smooth manner. How can you say that event was conducted in a smooth manner? It was smoothly conducted. There was no case of indiscipline. I cannot remember. You were the housemaster of which house? Lassit House. You had come to the vice principal stating that one of the type of rope is broken. Sir, cadet will approach me, and then my house captain and school captain approached me to report it to senior master, and after that they continued. Then how can you say that event was conducted in a smooth manner? Sir, it may be noted that it may not be conducted. Conducting an event and conducting an event perfectly, there is a difference. Sir, I said because the rope of the tire was broken. You approached the vice principal. My house captain approached for the time compensation. What do you observe other than that? Other than that, nothing. After all, the result was withheld and event was cancelled. Why the event was cancelled? For approaching for the time compensation by the boys. Why the result of IHU obstacle competition was not declared? Because the boys approached for compensation of time, event was cancelled. Because of the event was cancelled. Because of that event was cancelled. Yes. When the event was conducted, the housemaster were not given any duties. What they were supposed to doing that time? Sir, we be with the cadet to motivate to participate. Why there was an incident of shouting, running here and there using unparliamentary language? That was not from my house. Lassit House was making advance celebration before the declaration of any result. That is not lie. In the event was conducted properly, equally responsible to be given to the housemaster, as they had also responsible for the cadet discipline and conduct of the cadet. Everybody is involved. Housemaster will leave behind to look at.
Anything more substantial, Ade?
Yes.
With regard to the article of charge number 3, Mr. Das at the outset has submitted that the same is vague to the core of it. He has by referring to the statement of invitation in connection with the said charge has contended that the same only projects that the event, that is IH obstacle competition, was cancelled due to indiscipline of the candidates and mismanagement by the in-charge. Misbehavior by the candidates was also noticed during the conduct. Mr. Das submits that in the inquiry proceedings, 3 witnesses were examined by the board, by the inquiry board, in respect of the said charge, and the said witnesses were SM Rahman, Sanjeev Deca, and PK Odhikari. It is contended that a perusal of the statements as made by the said witnesses does not bring home the charge now leveled against the petitioner, even if that the same is read with the statement of imputation as contained in the show cause notice. So it is contended that the finding of the inquiry officer as recorded with regard to the said charge are all based on surmises and conjectures. Also, it is also contended by Mr. Das that referring that the witnesses, more particularly Mr. P.K. Adhikari, had in his statement submitted that the event was the responsibility of all and cannot be said to be the sole responsibility of, sole responsibility of the
Yes.
petitioner. Accordingly, it is submitted that the findings as recorded by the inquiry officer in the matter does not merit acceptance. Mr. Das has further said, further by referring to clause 8 of the finding with regard to finding of the board with regard to article of charge number 3, wherein it stated that the 7 and 8, Roman, wherein it has been stated that the petitioner had accepted his failure being the in charge of the event. You have accepted,
Sorry,
you have accepted that
no.
is
Possible.
disputed, and Mr. Das refers to the written statement as well as the representation as made by him in the matter against the inquiry report.
Yes.
Mr. Das, I
Yes.
think we cannot proceed any further.
Yes, my lord. True.
We'll have it on Tuesday,
Tuesday.
Yes,
Tuesday is
subject to the division bench, huh?
Yes.
We type करके file में डालते हैं। ये तो file move video,
14th month.
put it. List
Look,
again on
Can we have one Monday, if not in?
13, no problem.
13.
13.
You know,
Not like he'll only continue. You let your junior be here with the
So that
records,
yes, ma'am.
and thereafter trouble
Yes,
Mr.
ma'am.
KL
Yes.
to come down so that I don't have to
Yes,
have
ma'am.
2 heavyweights on me on the same day. 14, 13, huh?
13.
13.
ये तो file को ये तो by slip video. After rising, huh?